It'll be an opportunity for the administrative hierarchy of our superior courts to comment on our legal system and to set tone for what the future of jurisprudence in this country should be. In this regard, may I now invite Chief Justice of the Honorable Islamabad High Court, Honorable Mr. Justice Ather Minallah, for his comments.
Honorable Chief Justice of Pakistan, Honorable Chief Justices of the High Courts, Honorable Judges, distinguished guests, ladies and gentlemen. I must admit that I was not thrilled to read the topic to which we have been asked to speak about in this session, as it requires introspection and self-accountability. To hold oneself to account while being used to holding others to account in the work that we do on a daily basis does not come very easily. On a lighter note, I asked my brother judges in the Islamabad High Court what might be an appropriate title for this brief talk. Some serious suggestions were followed up, and movie names were suggested in a lighter vein. One such suggestion in relation to the role of judiciary in strengthening rule of law was the good, the bad, and the ugly. This seems the most realistic, and so I decided to go with it. I must clarify at the outset that we have all sworn on oath to preserve, protect, and defend the Constitution. And I'm sure that in our individual capacities, we all believe that we abide by the oath we have sworn every day while in office. But today, we have to evaluate how a bystander might perceive and evaluate our success in upholding rule of law and supremacy of the Constitution. Let me first address the ugly in the good, the bad, and the ugly. As an institution, we cannot be oblivious to the fact that history's judgment of our performance thus far might not be very flattering. We have contrived concepts such as holding the Constitution in abeyance and justified the doctrine of necessity. We authored cases such as Doso, Nusrat Bhutto, Zafar Ali Shah, and Tikka Iqbal Ahmed Khan, while having sworn to protect and defend the Constitution. We as an institution sided with usurpers that were all powerful and decided against them mostly when they had fallen out of favor or had walked into the sunset. We sent an elected prime minister to the gallows, and it is ironic that we don't accept the judgment as a precedent. The disqualification of chosen representatives under Article 62(1)(f) of the Constitution has raised many questions. It has raised questions because such a high standard of scrutiny has never been applied in case of unelected usurpers and other public office holders. But as we take note of decision rendered by the judiciary, where it became an accessory to undermining the Constitution, we also decided cases as Asma Jilani, Asghar Khan, and the Dharna case, wherein we explained that representative democracy was the foundation of the scheme of our Constitution, while reiterating and emphasizing that under provisions of the Constitution, legal authority and legitimacy flows from the people and their representatives and not from unelected and unrepresentative institutions. History will judge us for how we refuse to sit in judgment over those who trampled upon the Constitution. Nothing will be gained from denying history, but much can be gained by learning from it and resolving not to repeat our institutional mistakes. We must hope and resolve that the manner in which we discharge our responsibilities is such that we redeem ourselves and rise to the expectations that the framers who scripted the Constitution had from the judiciary, when they declared the judiciary to be an independent pillar of the state and endowed it with the responsibility to uphold and enforce the social contract between the citizen and the state. The independence of judiciary that we jealously guard is for the benefit of the average citizen and relies on us to uphold the promise of legal equality made to him by the Constitution against an all-power state and the power elites that control the state. Many in this country regard the judiciary as part of the power elite as well. We must therefore bring the same attitude of introspection and humility when it comes to exercise of authority involving our own entitlements. When we exercise public authority to uphold our dignity, we must remember that the power is meant to serve public interest and not our own. Today, speaking plainly, we are a very polarized polity. This places a special burden on the judiciary, which is the ultimate arbiter of the law and the Constitution in disputes between various parties. We must conduct ourselves in a manner that does not bring our moral legitimacy, sociological legitimacy, or legal legitimacy into question, as we are the ultimate dispute resolution mechanism in the state. We cannot refuse to adjudicate legal aspects of disputes that produce political consequences. These are the cases where the legal analysis is not difficult, but the political consequences of correct judicial decisions can be far-reaching. The courts around the world tend to get influenced by consideration of political consequences their decisions will produce. We must remind ourselves that political consequences of judicial decisions are an extraneous consideration that we have sworn in our oaths not to bear in mind. There is no shame in admitting that we are an unelected and unrepresented institution. This is so by design. It is to ensure that our interpretation of the law and the Constitution is not influenced by the transient emotion of the day, irrespective of who we decide for and who we decided against. In a case that produces political consequences, a large section of the society will be critical of us. This is the burden that comes with the work we do. We cannot shun the burden, but what we can be confident of is that if we abide by our oaths and exhibit fidelity to the law and the Constitution, the reasoning of our judgments will sustain our moral, sociological, and legal legitimacy as an institution in the medium or long term. The executive and the parliament are institutions run on the basis of partisan loyalties and ideologies. The parliament can afford to be polarized, and the executive, as a reflection of the parliament, can understandably be one-sided, even if extreme one-sidedness is undesirable and unhealthy for both the executive and the parliament. But we, as a judiciary, cannot afford to be polarized. as we have no ideology or loyalty other than the law and the Constitution. We can disagree with one another, and such disagreements form the part of the judgment we render and the dissents that come along with the judgments. Such disagreement must always be rooted in our understanding of the law and not personal likes and dislikes. We have sworn an oath to shun personal likes and dislikes in discharge of our duties, and in this regard, I, as the Chief Justice of Islamabad High Court, am grateful for the collegiality that we have in our court. Let me speak now of the good and bad. I cannot feign ignorance to the popular sentiment that judiciary as an institution must be better. I endorse such sentiment. We are aware that people of the country pray for efficient and economic administration of justice. We have a huge backlog. Judicial decisions are not always up to the mark. The manner in which cases proceed through our dockets is not swift or transparent. People sometimes find the reasoning of our judgments wanting. They sometimes raise question about the integrity of the judicial system. We cannot condemn such criticism. We cannot deflect and pass the burden to other institutions. And we cannot pretend that the state of affairs within our institution is hunky-dory. The manner in which we presently administer the court system, to be honest, is not sustainable. We must improve the governance of the court system. We must engage the stakeholders to transform the judiciary into an institution that is focused on service delivery and gives priority to the needs and concerns of the consumer of the justice system, who despite all odds comes knocking to the doors of the district courts. We have given the life cycle of our system of administration of justice some thought at the Islamabad High Court. And we have put together a blueprint of reforms that we must expeditiously initiate. We released a concept paper for the much needed reforms in July this year, and the concept paper has been uploaded on the website of Islamabad High Court to invite public comment. To reform the court system is not an easy task, I will confess, despite the best of intentions. But what I can assure everyone is that we will try our best. We might make mistakes, but we will learn from them. We will try not to repeat them, and we will welcome all criticism, especially constructive criticism. And in this endeavor, we will need everyone's support. While admitting that our performance as an institution is wanting, I must also tell you that we must not look all woe begone. This is what brings me to the good from the title of my task. If we were to count each and every member of the judiciary, the total number comes to around 4,161. Yes, this is the sum total of judges that serve the needs of the country of approximately 220 million people. A civil judge who starts work at 8 a.m. in the morning plows along till late in the evening. Ladies and gentlemen, a civil judge has to work into the night and on Saturdays in cases that involve research, study, and deeper appreciation of the law. The amount of work that a civil judge is required to do on a daily basis might be equivalent to the work that similarly placed judges in developed democracies do over a fortnight. those who argue that case pendency is growing because judges are lazy or don't put a longer hours are either ignorant of the conditions in which judges work or the real problems that are choking the court system. Can we work more? The answer very fairly is no. But can we work better? The answer is, of course, we can do better. And to do it better, we have put together the concept of reforms that I have already spoken of. Please feel free to critique our performance, as that gives us food for thought and inspires us to review our own efficiency and manner of doing things. But please remember that judges don't work in isolation. There's a demand and supply equation that is choking the court system. This will need to be fixed, or judges will drown under the quantum of work thrown at them every day. I don't wish to blame any other institution of the state, as it is for them to realize that they too need to do better, as the people of the country deserve better. Let me just say that while we are at an embarrassing place in the global rule of law index, most of the factors that determine the ranking of Pakistan on the index are not linked directly to the judiciary. Let me give an example to explain this problem. One of the functions of the High Court is to undertake judicial review of executive decisions that are illegal, irrational, or procedurally improper. If the executive was an example of good governance, a large number of the grievances that come to us for resolution would wither away and our dockets would not be choked as they are. The demand and supply issue is one that the executive and the parliament must also look into. Bad laws create an incentive to initiate litigation. It is not for the judiciary to write laws. Giving effect to laws is the job of the executive. If executive authority is exercised in a manner that is just, fair, and reasonable, there would be a lot less aggrieved citizen knocking at the doors of the courts. While I stand here to admit our own failings and limitations and promise to try and be better, I would invite the executive and the parliament to indulge in introspection. Fixing the justice system doesn't fall within the domain of any one institution. We will need to do this together, and we must act now. This is the least we can do to rise up to the expectations of the citizens of the country who have placed their trust in us and for whose interest we have been called upon to serve the country. With these words, I thank you, Your Lordship. Thank you very much.